Hi, welcome to the Schedule Loss of Use and Disability Duration Guidelines. Just as a reminder, we're going to just go through the administrative part of it. This presentation is for instructional purposes only and is not legal advice as to any particular matter. Does not create attorney-client privilege. LOIS Law Firm is a CLE accredited provider and authorized by the New York CLE Board to offer accredited courses. This course is offered in a live classroom setting. It's offered free of charge, and it entitles the attendee to 1 hour of CLE credit. You will get transitional credits. CLE course has been approved in accordance with the CLB award for 1 experienced attorney professional practice requirement. To comply with CLE requirements, the presentation may be recorded. Everybody should have the handout materials with them. If you did not receive the handout materials, let us know. You can't get CLE credit without them. Put away any devices that buzzes, may otherwise distract you or any other attendees. Everybody at home and here as well is encouraged to ask questions, and attendance of remote attendees will be verified electronically. After the presentation, everybody must sign out on the sheet provided. All attendees will be provided a link for post-instructional evaluation and asked to evaluate the presenter of the handout materials in the physical setting. All attendees must complete the evaluation, and you will get a CLE credit certificate of attendance, which will be available for up to 4 years. So today we're going to go through a number of topics: maximum medical improvement, schedule loss of use, using the disability duration guidelines to find the degree of impairment in schedule loss of use cases, and best practices on presenting guidance on exposure and settlements in schedule loss of use cases, using both litigation risk and discounting in determining SLUs. So maximum medical improvement is a term of art. It's commonly referred to as MMI. The guidelines state that when an impairment should be determined for most body parts is within 1 year from the date of injury or date of treatment. The claimant has recovered from the work injury or illness to the greatest extent that is reasonably expected, and no further improvement is reasonably expected. The need for palliative or symptomatic treatment does not preclude a finding of MMI. So this means claimant might not be back to where they were. They might not be back to baseline, but they're not going to get any better, right? The best they're ever going to get, and that's when we should be looking for an MMI finding. The guidelines also state that the need for palliative or symptomatic treatment does not preclude a finding of MMI. So this means if the claimant's getting pain management, something like an injection, just cortisone injection, right? To manage their pain, it doesn't preclude a finding of MMI. And maximum medical improvement, it cannot be determined prior to 6 months from the date of injury or disablement unless agreed to by the parties. So we can stipulate to an MMI finding prior to 6 months, but absent that, we're not going to be able to get a maximum medical improvement finding before that. According to the workers' compensation guidelines for determining impairment, finding of MMI is based on the medical judgment that the claimant, number 1, has recovered from the work injury to the greatest extent that is expected, and no further improvement is reasonably expected, and this is pursuant to Chapter 1.2 of the 2018 impairment guidelines. Claimant will inevitably, right, try to delay their finding. Why would they do that? Because it increases the value of their claim. And there's 2 main ways that we see that. The first is through a surgery. We get an MMI report. Claimant hasn't treated for a year. All of a sudden, that surgery that they talked about, like way down in that report, it's requested. Or they talk about it more and they say the claimant now wants to pursue it, right? So the law states that a mere assertion of the possibility of a future surgery is not a bar to maximum medical improvement. So we should always, as litigators, we should always be looking to see whether or not there is an active request in the board file. It's not enough to just talk about the surgery. We actually have to have an active request in the file. In addition to that, the claimant needs to have an actual, not only qualify for the surgery, but also have specific plans for surgery, including an active request for pre-authorization. Now, a way for us to get ahead of that is to know what the guidelines are, right? Know exactly what the injury is, know what the guideline requirements are, and see if the claimant qualifies for it. If they don't, we can inevitably tell the client, listen, even if the claimant wants it, he's not going to qualify for it. So we get ahead of that request, right? So the other way the claimant inevitably tries to prolong the life of the claim is through adding additional sites. Claimant gets injured to the right arm. We get the MMI finding all of a sudden, oh yeah, I forgot, I injured the other arm. The way to really restart the clock and entitle them to not only an additional award, but additional like temporary disability awards and temporary total disability awards in the interim. So it's essentially a way for them to reset the claim. And how do we challenge that? We challenge that by taking the testimony of the treating physician and presenting contradictory medical via IME or records review. I also like to, if it's a very distinct injury with a very distinct mechanism of injury, I'm always going to ask for number one, the incident report. Number two, I'm going to ask for mechanism of injury testimony. I'd at least try to ask the law judge to get that in addition to an employer witness as to what the mechanism of injury was and what was reported at the time of the injury. You want to aggressively fight that via lay witness testimony as well as medical testimony, because essentially we don't want the claim to start over. All that hard work we did in getting that MMI finding, just going to be gone. So it's important that we are very aggressive at that point. C4.3, you guys have all seen that at this point, but essentially it's the form used by the doctor just to show what the permanent disability is. And they should, if they fill it out correctly, lay out the three range of motion for the injured extremity, explain if the contralateral is involved, whether special considerations apply, and then list the degree of the impairment. So what is schedule loss of use? Schedule loss of use is defined as, or is explained as not compensating the injured worker for pain or suffering, and not representing damages for a loss of a finger, foot, or other member, but instead is award to compensate for loss of earning power. And unlike other workers' compensation awards, the amount of the schedule loss of use is independent of the lost time the employee actually loses from work, and is instead statutorily fixed. So this means the claimant can have no lost time and still be entitled to a significant schedule loss of use award. And the schedule loss of use award is a legal determination made by the board based on the medical evidence of residual and physical functional impairment, considering consonance with the impairment guidelines, as well as other evidence relevant to the claimant's prospective loss of earning power. As most of you guys know already, it's limited to these specific body parts, mostly the extremities. And then each body part has a certain amount of weeks that it's valued at, with the arm being the most and the fingers and toes being the least valuable. And how do we litigate schedule loss of use? We first get an MMI finding. Both sides then get their own impairment ratings. We take the medical testimony, and then the law judge will rule on schedule loss of use. So schedule loss of use was a construct that was created by the legislature about 120 years ago, which they just decided that as opposed to a LWEC for the back and the neck, where you lose, where you get an award based on the loss of earning power, this would be based on a loss of use of each one of these body parts, as opposed to a loss of earning power. So two separate and distinct ideas about how the claimant is entitled to the award. So in addition to that, they also decided that there was a normal healing period for each one of the body parts. I don't know, this was based on medicine about 120 years ago, but in their infinite wisdom, they decided that the arm heals, a normal arm injury heals 32 weeks, normal leg injury 40 weeks, and so on. So, and they determined that if the claimant's injury is worse than that, or it takes longer for the claimant to heal, and they're out of work and entitled to awards at the temp total rate for longer than these periods, they should be entitled to an additional award on top of the slew award that they're entitled to. So, for example, If you look at a 35% loss of use of the left arm, we get an award of about $105,000. The claimant received awards at the temp total rate for about 34.5 weeks. And then, so the normal healing period for the arm would be 32 weeks. So the claimant would be entitled to an additional protracted healing period award of 2.5 weeks. So we would add the award the claimant would be entitled to, and then add the PHP award of 2.5 weeks on top of that, and we get the gross award. And of course, this incentivizes the claimant to be at the temporary total disability for as long as possible. So it's important for us to get IMEs as soon as possible to take the claimant off the temporary total disability award. It's also imperative that we ask for depositions as early as possible so we can start to get the claimant off the temporary total disability award as well. We want to avoid PHP because it's going to increase the value of the award significantly, and we want to be aware of it from the beginning of the claim. My other thought on getting depositions early as a claim is that we're not teaching. If we get concessions from these doctors early in the claim, we already know how they're going to testify. We have these great concessions, and we're not reaching scheduled loss of use, and all of a sudden, oh no, we don't know how the doctor's going to testify. We already know they're going to testify in a certain way, and they haven't testified credibly. We can use those concessions down the road. I don't like waiting till the end of the claim for that. So while PHP serves to increase the value of the claim, there are ways to decrease the value or mitigate our exposure. One of those ways is apportionment by prior use. So the pivotal case in that is matter of Genduso, and that was a case where the claimant had a prior SLU award to the same body part. So in that case, the court decided that the claimant had a 45% use or a prior 20% loose of the right arm in 2016, and then had a subsequent injury in which it was 45% cause related. You would subtract one by the other. So the subsequent SLU would be mitigated essentially by the prior SLU. And it's a straight subtraction. So we look at this, we get 45 minus 20% equals 25% scheduled loss of use of the arm. That's simple enough. That's where we have a shoulder injury and there's another shoulder injury, same body part. It's a little more complicated when we have some members involved. So as you all know, we get a scheduled loss of use, or our statutory arm is both the elbow, right, and the shoulder. So when that happens, it's a little more complicated. And there's two recent cases that commented on that. That would be matter of Johnson and matter of Luini. And they state that if the claimant proves that the second injury is not in conjunction with the previous disability, then the claimant is entitled to the SLU with the increased loss of use. So there's a lot there to dissect, but essentially the way I read that is that the claimant has to prove that one injury is distinct from the other, even if it's the same submember. But what we should be aware of is that there is the possibility we won't get that credit if it's the same submember. From a litigation standpoint, we want to always look through our reports thoroughly. We want to see, do the doctors that are commenting on scheduled loss of use, do they even know about the prior scheduled loss of use award to the other subpart? Because a lot of the time they don't. And if they don't, it would be my argument that there's no way they can meet the burden of proving that two separate and distinct injuries. You have to know about the second injury to prove they're separate and distinct. So the takeaway for this, I believe, is that it's the claimant's burden to prove this. So let's put them to the proofs and argue and shape our questions to show that that there's no way they could possibly comment on that. And if they're silent on it, I would say they haven't met that burden, because there has to be some kind of comment in the report and they have to know about it. There is a third type. There's another type of apportionment that's not in here, but I want to talk about is Section 44 apportionment. You guys heard of it? Okay. So Section 44 apportionment is when the claimant has an occupational claim. Let's say the claimant's a truck driver or a construction worker. He does a lot of heavy lifting. He injured both arms, right? Two scheduled loss of uses, one for the right arm, one for the left arm. However, he's a union member, and he only worked for us for, let's say, a week, but he did the same job with the same duties for 30 years. What the law says is that we're going to be stuck with the loss because we're the last injurious exposure. But the law also allows us to seek Section 44 apportionment, meaning that we can go after all the other employers in which the claimant did the same job duties. And what would happen is there's a whole process, but essentially we have a date of disablement, which is the date that the law judge determines essentially that the injury happened. And there's also a date of contracture. And the date of contracture is when the law judge is something we litigate, and it's when it's determined that the exposure that the claimant had, the occupational exposure, started. So what would happen is when we get to schedule loss of use at the end, schedule loss of use, we would end up paying out the whole thing, but then we can bring in all these other employers, and each would be responsible for reimbursing us pursuant to the amount of time that the claimant worked for each one of those other employers. So it's a very powerful thing. So especially if we know that they only work for us for a short period of time, is that we can get, I've seen 99% of the SLU award back at the time if we litigate it properly. So it's a very powerful form of mitigating exposure on a claim. Okay, how do we calculate schedule loss of use? Percentage of the body part equals the number of weeks times temp total equals the gross amount. We take credit for prior awards. The employer would add the PHP if it applies, and then we would calculate the net award. Gross amount minus prior indemnity plus PHP minus the attorney fee equals the net award to the claimant. And we're going to go through an example. The body part is the left knee. Temp total rate is $700 a week, 72 weeks for 25% schedule loss of use. $50,400 gross award. With apportionment, we have a left knee injury, same left knee injury, $700 per week, 72 weeks, so that the gross award would be the same, but we get an opinion from a doctor that says 40% is apportioned to the prior claim, and we would only have to pay 60% of that award. So the third way to do that, let's say there is no prior work-related injury or schedule loss of use award, or the prior injury has not yet reached MMI, we can get an opinion asking for apportionment between the two dates of loss and try to figure that out, and then each party would be responsible for a certain percentage of the schedule loss of use. What is imperative in doing this type or seeking this type of opinion? The doctor that reviews the most medical records or has the most thorough knowledge or the more thorough knowledge as to the treatment for each one of the claims and the extent of the injury for each one of the claims is likely the one that's going to be found more credible. So it's imperative from the beginning of the claim, if we know there's priors, we see it in the ISO, we see it, we get an OC 110A, we know there's a prior, it's imperative that we get those records as soon as possible. And when the time comes for permanency and we want an apportionment opinion, we provide all those records to the doctor. We should remember that the temp total rate is subject to the rate cap, and the statutory maximum is going to continue to increase over time, as is the statutory minimum. Okay. Now we're going to go to the disability duration guidelines. We're going to talk about how it's organized, how impairment is determined, and how special considerations are applied, and what doctors are supposed to do versus the judges. Okay, so each chapter is broken down pursuant to a body part or a type of loss of use. The doctors determine impairment, and it's a purely medical determination made by a doctor or a medical professional defined as anatomic or functional abnormality or loss. Requires a complete examination and accurate objective assessment, and considered permanent when MMI has been reached and there's a remaining impairment. Judges determine disability. It's a legal determination that reflects the impact of the workplace injury on the worker's ability to work. And the workers' compensation law judge establishes a level of disability based on the available medical evidence and other relevant information. Then chapters 2 through 9 essentially break down how to calculate schedule loss of use. First chapter talks about how to perform the examination and what the doctor should be looking at, and the rest kind of break down how, for each body part, you're going to determine schedule loss of use. So determining impairment, the doctor, when evaluating the level of permanent residual physical deficit, the contralateral side should be considered in comparison for the expected normal values when appropriate. Only if the contralateral limb cannot be examined should the normal range values be used. Why do we do that? The claimant's 70 years old and he could barely move either arm before the injury. And he only has one injured arm. Why should he be compared to normal range of motion, right? His range of motion was bad in the first place. So we should be using the other contralateral extremity unless there's a workers' comp injury on the other one as an example. If you think about it, it actually makes sense. We should be looking to objective findings of the physical examination and data contained in the patient's medical record, not the severity of injury. Must follow the guidelines in opining about impairment, and a goniometer should be used to measure active range of motion 3 times taken. Deficits should be measured by comparing the baseline reading to the contralateral member, if appropriate. This is an important opportunity for cross-examination, and the doctor is expected to apply special considerations for some body parts conditions, and instructions have clarified whether a condition falls under special consideration is evaluated as a standalone or as a value that is added to the range of motion deficits. So, first of all, in the last month, I know we posted internally at least, there was a third department case that talked about how if the doctors don't perform a proper examination of the claimant, then the law judge would be proper in determining essentially that the report is not worth the paper it's written on. They said the guidelines have a purpose, so we should be, I can send a citation to you guys later, but we should be citing that every time at this point. If we notice, looking through the report, did the doctor list all 3 findings? Are they active? Are they the best effort? Was the contralateral member looked at if appropriate? If he didn't do any one of those things, then he didn't do a proper examination, and we should be not only asking across examination, but citing that case law. Okay, and the other part, special considerations take a while to learn, but there's case law out there that has stated, so the way it used to work for special considerations was we had condylomalacia patella, which is one of the, probably the one we see the most, essentially just arthritis of the knee. The guidelines state 7.5 to 10% for condylomalacia patella. So before this case, Matter of Blue, which came out in the last few years, if you had condylomalacia patella, you would only be entitled to that 7.5 or 10%. But now, after Matter of Blue came out, it changed things and said if there's another finding that would justify a loss of range of motion, so let's say there's a meniscal tear across condylomalacia patella, then a doctor is justified in adding the range of motion on top of the special consideration. So it's important to look through the file, know what the findings are, and to see if it's just strictly condylomalacia patella, the doctor could still limit it to that little 7.5 to 10%. But if there's another finding in there that could any finding that could justify a loss of range of motion, the doctor is justified in adding it. And then there's other ones that specifically already consider it. So if you look at biceps tendon rupture, you look at other ones, sometimes they'll include the range of motion in it, and then you can't. So it might say like include the single greatest deficit on top of it. You can't add all the range of motion findings. You can only include the one. So be careful, read the special considerations very carefully. This is just an example of how a range of motion finding for the shoulder, and just shows each one of the percentages. And essentially, so this is just an example of a goniometer, which is essentially a protractor in which the doctor measures active range of motion, and this would be for the knee. And for each one of the chapters, you're going to see some kind of charts that are similar to this. The doctor should always be using this goniometer in order to measure the range of motion. The 2018 guidelines at I believe, one of the appendixes on the last page, there's essentially a cheat sheet for percentages that tells you 5%, 7.5%, how many weeks. Could be a preference for you guys to use that. It's a reference you have, but it's just as easy to just multiply the percentage by the number of weeks for each body part. So our best practices is to always check the findings of the evaluating physician to make sure they support the impairment percentage, double check whether the contralateral minimum measurements were taken and used, and did the claimant have worse findings in the C4.3 permanency exam than they did during treatment. For example, did they have better range of motion and physical therapy notes? So this is about knowing your file, right? When we look or evaluate a C4.3 or an IME, we want to look at the file as a whole and not just in a vacuum. So was the range of motion that the claimant exhibited at the IME significantly worse than it was for the rest of the time the claimant treated? If so, the claimant was likely magnifying the symptoms. It's especially true where the claimant, for schedule loss of use, because the claimant can miss no time of work, continue to work full duty, do a heavy duty job, and then all of a sudden come back with a 60% schedule loss of use opined by his doctor. So it's important that we know the file, look through the treatment, and then if we do notice a significant gap, we should be considering number one, is there a potential fraud? We should be recommending surveillance. And we should be aware that there's a case called Matter of the OCCS Coxsackie, which says that we can look to the prior examination findings for the treating doctor if we believe there's a significant disparity between what was exhibited at time of permanency and what he previously exhibited in treating with the same doctor. And that case pretty much says in that specific case, there was no other explanation other than there was a monetary award at issue. And the claimant knew he can get an increased award. So what they did is went back and used the prior range of motion findings in determining the award. So we should always be skeptical about what we see if there's significantly worse range of motion at the time of permanency. Evaluating exposure. So we went through this before, is we calculate the gross amount, we take credit for prior awards, we add money for the protracted healing period, then we subtract the attorney fee, and that's the claimant's net award. Both sides typically get permanency reports. They often, the doctors and the treating doctors often disagree on the nature and extent of impairment. And most commonly, we see the treating doctors finding more disability than examining physicians, but there's occasions where I see it go the other way, and we should be just as skeptical as that, both ways. It's okay to be skeptical of the claimant, even if it's with our own provider, and just because the claimant is the one that controls his range of motion for the most part, especially with active range of motion, which has a very significant subjective component to it. And it's less common for the physician C4.3 to disagree on the body parts affected. Most common injuries have a narrow range of impairment findings, but doctors will rarely completely agree. For example, a partial meniscal tear has a typical range of 15 to 25%. We should be, as pointed out earlier, reviewing the report compared to prior treatment records, and knowing we should also try to look through, we have a whole database of deposition transcripts. In Practice Master, we should be looking through those to determine how the doctor testifies to impact any settlement recommendation that we provide. Okay, so when we're evaluating for settlement, we should first be evaluating the medicals strictly based on what they say first before we discount it. So our report says this, their report says that, and then we should discount according to what we believe, credibility issues, litigation risk, and all that. So we consider litigation risk to both sides, their trial cost, likely outcome. Do we have covert surveillance that impacts credibility? And why not try a case when there's a really high schedule loss of use number? We should consider the value of right now money to the claimant. We use ATF values to discount present value, and we should consider indemnity only where future medical is likely to be minimal or unlikely. Okay, and special bulletin 222C is where we determine present value. We just look at the number of weeks claimant be entitled to, and then use the multiplier. So when we're talking to our clients, there's certain lingo we want to use. We want to make sure we don't use certain lingo. So as defense counsel, we recommend the amount of settlement authority for our client to extend to us. We ask for dollars, not percentages. We make offers. We make counter offers. We solicit demands. We don't make demands. We don't ever refer to the claimant's demand as a claimant's offer. We don't ever tell clients the claimant's offer to settle is, and we don't ever recommend paying 100% scheduled loss of use absent an amputation. More importantly, I think we don't want to strictly be a calculator. We want to make recommendations to our client. We want to evaluate the scheduled loss of use opinions, figure out which one is more credible. Is our doctor more credible? Is theirs? Are they both incredible? That's going to really help you determine what you want to tell the client, right? If both the reports are really, really bad, you might either want to try to litigate no credible evidence of permanency, or you might want to do a split because you know it's not going to go well for us. If our report is more credible than the other, it might be like, okay, let's just hold firm, let's not split, or if we do, let's go closer to what our IME says and hold firm on that. If theirs is better, then we might want to agree to a little more, have flexibility, try to do the split, and then if they don't agree to that, maybe go a little more because we know we're going to be stuck with a much higher schedule loss of use. So use what you know about the doctors, use what you know about the guidelines, and make your recommendations. We do not want to provide a range, though. We want to say, okay, or a broad range, because if we do that, we're not telling them anything. We're just saying, could be 25%, could be 75%. What does the client learn from that? They learn nothing. So we want to provide an educated guess about where we think it's going to end up and stick with it, and then base our authority recommendation based on that. We should not assume that the client wants to settle. They may have a reason they don't want to settle. That may be union reasons. There may be a lot of other reasons they don't want to settle, but we should be on the same page with our client. We should be aligned with them. And we don't ever ask for settlement authority strictly in terms of percentage. We want to give the monetary value. We do not want them to have to figure out what the schedule loss of use award is worth. So we're asking for 17.5%, and we're not telling them what's that worth. What the value of that is, then they're going to have to figure it out on their own. We should just make it easier for them. Give them the amount, 17.5%. We're asking for $30,000. Makes it easy. They know exactly what they're agreeing to, and they don't have to think about it. Okay. Schedule loss of use settlements. Most schedule loss of use cases resolve by way of stipulation or judgment. We should be aware of the statutory maximum and minimum, which means we have to be aware of the date of loss for each one of these claims. We should not forget to subtract prior temporary disability payments made. And we should, although FROIs are starting to become more reliable, I still believe they're not always filled out correctly. So the best evidence of figuring out prior awards should always be the payment ledger. And I know my best practice is to ask for it periodically. So whenever we try to reevaluate exposure, we know exactly what the actual exposure is. It just makes it easier. You know what you're agreeing to. And as we reevaluate exposure, as circumstances of the claim changes, whether it's claimant had surgery, we see the range of motion increased, we can constantly give exactly what the claim is worth as time goes along. For stipulations, there is a new form 300.5. So just added a few extra, well, actually a lot of extra little parts to it, but for you guys, it'll be easy because it's part of the workflow. Everything will just autofill. But does anybody know the reason we use 300.5 as opposed to any other form? Okay. The reason we use it is because as opposed to any other form, so there's another form 300.12.5, which will end up resulting in a conciliator decision, so a proposed decision as opposed to an actual decision from a law judge who will review it. The difference between the two is that 300.5 is reviewable. So if we put everything properly in the form, but the law judge improperly implements it in the NOSD-SL or notice of stipulated decision, or in the EC18 that we receive after a hearing, we can essentially ask for a modification or appeal it because it's an appealable one as opposed to the other form, which is not. So we always want to, this is the reason we use this form, and it's the reason we always want to use that form. So what do we need to know in order to complete a stipulation? We need to know, number one, the established body parts, the average weekly wage, the temporary total disability rate. We need to list out the period of temporary total disability awards. Why do we need to do that? Because We want to make it easy for the board to determine whether there's protracted healing period. And actually they require it at this point. So we're going to list out the claimant received 5 weeks at the temporary total disability rate during this time period. We're going to look at the notices of decision as well as our FROIs in order to determine that, or the payment ledgers. And then based on that, we can determine if there is PHP, a certain number of weeks, or there is no PHP. We're going to figure out the percentage schedule loss use, the number of weeks it entitles to, the amount of PHP, prior awards, gross to claimant. We subtract the attorney fee, we get the net, and then if there is no PHP, we specifically want to tell the board that there is no PHP. And we always are going to reserve our Section 29 rights. Even if even if there's a third party that's settled already, there might be another third party we don't know about. So we always want to reserve our Section 29 rights. Okay, so key tactics. The concept of PHP serves to increase schedule loss of use awards when there have been long periods of temporary total disability. This is a reason to challenge payment of temporary total disability benefits, and this is why we always talk about requesting depositions and not agreeing to TR rates. Our role is not just to choose the middle of the two competing physicians' opinions, it's to advocate for the correct application of the disability duration guidelines and challenge biased reports, and we should constantly be reevaluating the value of the case as litigation progresses. So even as paralegals, you guys can just look at prior reports. Let's say you just get a list finding of a new med-nar, but when I do that, I would just look at the previous med-nar and see, did the range of motion increase or decrease? It's a good opportunity to do a new settlement exposure evaluation. So if the range of motion increased, then our exposure will likely have gone down. And if the range of motion is decreasing, it's something we want to tell the client because they should know the claimant's range of motion is worsening and that we might want to get surveillance or do something else with that claim. Each step in the SLU determination process is an opportunity to leverage for settlement, identify the stakeholders early, who needs to be a part of the settlement authority process. Please subscribe to our newsletter, listen to Christian's podcast, and remember to sign out after this and complete the evaluation. I don't see any questions at home, so thank you guys.